Are secondary boycotts legal under labor law? Imagine a workers' union trying to put pressure on a company. They want to support their members but also have to follow the rules of the law. So, what exactly does the law say about their actions? Let's find out. A secondary boycott happens when a union targets a company that is not directly involved in a dispute. Instead, they try to pressure a third party, like a supplier or customer, to stop doing business with the primary employer. The goal is to make the primary employer change its ways by hurting its business relationships indirectly. Under U.S. labor law, most secondary boycotts are illegal. The main law governing this is the National Labor Relations Act, which was passed in 1935. This law was later amended by the Taft-Hartley Act in 1947. These laws say that unions cannot picket, strike, or do other activities aimed at neutral companies just to force the primary employer to settle. The law makes a clear distinction between primary activity and secondary activity. Primary activity involves actions directly against the employer in dispute. These are usually protected by law. Secondary activity targets companies that are not involved in the dispute and is generally not protected. Such actions are considered unfair labor practices. There are some small exceptions. For example, unions can hand out leaflets asking consumers to boycott a product from the primary employer. But the message must be truthful and not coercive. Picketing that tries to force a neutral employer to stop doing business with the primary employer is still illegal. In practice, unions are expected to focus their efforts on the employer they are bargaining with. Targeting suppliers, customers, or other neutral parties is not allowed. If a neutral company is harmed by an illegal secondary boycott, they can seek help from the National Labor Relations Board, which enforces these rules. Recently, some legislative proposals like the Protecting the Right to Organize Act have aimed to change these rules. They want to allow some forms of secondary boycotts. But as of now, these proposals have not become law, so the current restrictions still stand. The reason for these rules is to keep peace in the industry and protect companies that are not involved in the dispute. Unions might see these restrictions as limiting their power to put pressure on employers. But the law aims to balance the rights of workers and the rights of neutral parties. So, to answer the question directly, secondary boycotts are mostly illegal under current U.S. labor law. The National Labor Relations Act and its amendments restrict unions from targeting neutral companies to support their bargaining goals. Violating these rules can lead to legal penalties. Any change to this law would need new legislation passed by Congress.